Right, so we'll reconvene the meeting. So I'll call the meeting back to order. And just a reminder of where we're at. What we will do next, as we'd always committed, is that we'll do the Yaldhurst Village Subdivision, item 26, next. And then we'll come back to Cranford. And then we've got item 23 still to do to complete the open agenda. And then we'll move into public excluded at that point. So that brings us neatly to item 26, the Yaldhurst Village Subdivision. Just a reminder of where we were at with this. Last week, 2 weeks, 3 weeks ago, might even be 3 weeks ago now, we had an open session and a public excluded session. We then had questions and answers in both of those sessions. We heard from a number of submitters. We heard from the community board. We went through question and answers. We went into debate. And then obviously at that time it was moved and carried that we would leave this matter lying on the table pending any outcome from arbitration. So my view of where we're at now is that we remain in debate. What I'm proposing is that we get an update from Rob on the arbitration question. I'll then be happy to take any questions on the arbitration matter, bearing in mind that we've already had questions and answers on the substantive issue, and then we'll continue with the debate. Well, we'll need to get a mover and seconder for something, and then we'll continue with the debate and make a decision. So on that basis, Rob, good afternoon. Welcome to the table. Thank you very much. Good and afternoon. If we can start by you giving us an update on the arbitration matter, which was the reason why we deferred this to this meeting.
Thank you, Mr. Chair and councillors. I communicated with both Infinity and the opposing group to clarify the details. So there was a hearing that was to take place the day after the last council meeting, and that was, as Councillor Turner has indicated, the reason for the deferral. That occurred. What it was a telephone conference with the arbitrator to set a timetable towards a hearing, and as I understand it, it has set a number of steps in a timetable. There is to be a further timetabling telephone conference in early September. And it's anticipated that a full hearing, if necessary, will take place in the first quarter of 2018. So it didn't resolve itself on the 7th of July, and it's heading towards a hearing in early 2018.
Thank you. So given that we've already had questions and answers on the substantive issue, are there any questions on the advice that we've just received, the update that we've just received? Okay. Jimmy.
One question, just want to know. If we go to the staff recommendation today, whether, the council will, have overriding the Resource Consent Act and also the overriding the Subdivision, the Resource Consent.
The short answer to that is no. The officer report that you have in front of you says to you, you have a question to answer under the 1974 Local Government Act. It sets out what boxes need to be ticked before that can be answered, and those boxes are largely relating to compliance with the resource consent, and the advice that the report contains says that yes, all those boxes are ticked so that you can make the resolution under the 1974 Act.
Thank you. Okay, so in order to proceed from here, I need somebody to move something. Question, Aaron, yep.
Yeah, so just my question is, and it refers a little to the 74 Act, is around that this is a dedication versus vesting, which normally happens. I've seen a few of those come through. Someone develops something, then comes into possession of the council, so on and so forth. This process seems very unusual, and so when something unusual crops up, I get concerned. Why are we going down that road?
The dedication process under 1974 Act and the other type of process which might be more common under the Resource Management Act are two parallel processes. The end result, a road, is the same. They are both equally legitimate processes for an applicant, a developer, to follow.
So then why not just use the regular vesting process that we usually have? Why? So my question is, why have they gone down this road?
Well, that's not a question I'm able to answer, but I suppose the only thing I can say in regard to that is, as you know, I've given legal advice to you about those matters in PX, but all I can say is that it is an application that they are entitled to make to you. It is perfectly normal, and a perfectly normal legal application that they're entitled to make, and that you are required to make a decision about.
So, and that may be the case because it does exist. It just seems odd that it's the first time for this council that it's come through this way versus the other way. Not saying there's never a time for first, but you normally do something in a particular way for a reason, and you change for another reason. I'm just not seeing that reason. But the other thing is, I've been made aware that there's a court case currently happening where the property owners are taking the developers to court for constructive fraud. Can that in any way come back on the council, or can we be implicated in that via this decision today?
I can't answer that question because I know nothing about the case, but perhaps I can answer it this way. If there is a case between people who are in a contractual relationship and they are suing each other for breaches of that contractual relationship, that would have nothing to do with the council.
Yes, but we do become involved in this by the dedication of this road, or we become part of it eventually, is the way that a development happens. So there's no way that we will get caught out anyway here?
The council cannot prevent people suing it. People are entitled to sue the council if they wish. I obviously can't give advice to you without a lot more detail about whether that would be successful if somebody did decide to sue you. What I am saying is that in a general sense, a contractual argument between two parties who are not the council is unlikely to involve the council in any legal risk.
Yanni.
Thank you, and sorry if you already covered this earlier. Just two questions. One is, who's the suitable guarantor? And the second one is, what's the relationship between the stormwater access arrangements and the dedication of the road?
Well, the suitable guarantor is somebody that we decide when the guarantee is presented is an acceptable party. So I don't have a name or a list that I can put in front of you, but that's just a matter of making sure that the guarantor is somebody who's generally is solvent and available to pay. Sorry, the second question.
We'll just, in regard to the suitable, can you just, given the history of this case, it seems like an incredibly risky thing to do.
Well, I can't. All I can say in that regard is, as I say, I've given you legal advice about what things you need to consider in respect of this application and what things you can't consider. Right. I can't really take that any further.
So the consideration of a suitable guarantor is not something that we should consider?
It's not something that I can. That issue isn't something that I can give you advice at this stage.
And the second question...
And I've already given advice about it.
The second question was, I was a bit surprised to be asked to sign some sort of stormwater agreement. So can you just help me understand what the stormwater relationship is? We heard deputations previously in that regard. So what's the relationship between the stormwater design and the roading and what we're being asked to do today?
So I think the answer to that question is this. As the report says, officers have checked this subdivision against all the relevant requirements of the Subdivision Consent and the Resource Management Act, and it complies. As the report says, that's what you need to look at and consider, and what that says is that the stormwater, what the situation is that the stormwater requirements as set out in the consent that's relevant to this question are complied with.
So I was just, I guess, I mean, it may just be coincidence, but I was struck by the timing of why we'd be asked to enter into a stormwater agreement a day or 2 days before we've got this issue coming back to us.
The stormwater agreement is not part of this particular application. Is not directly related to this particular application.
Right. So it's just coincidence that it.
In the sense of the question that you're being asked to decide today, yes.
Thank you. Dave?
Look, thank you. I'm hearing that in effect we are being asked to make a decision on this matter where we've been given advice that the course of action that's been taken is legal, and we really have little options on it. What I am still unclear on, although you tell me that the dedication of this road is a lawful process, till now I've still not, and this is the first time that this has been used by the Christchurch City Council, I still do not have any idea of the implications that arise from dedication versus vesting, and whether there is a distinct advantage to one or other party by going down this track. It's, as Councillor Keelan said, this is the first time, and when something unusually different to what we have done here arises, I would really like to hear why this option is preferable to having it vested.
As you've just seen, Mr. O'Connor has just got into my ear. So I may have been too cautious in what I've said. Mr. O'Connor tells me that this council has done this process at least 2 or 3 times in the time that he has been here, the latest being something to do with some roading at the airport.
still doesn't answer the question, what is the difference between dedicating a road and vesting a road?
For your purposes in making this question, asking this question, answering this, making this decision, there's no difference. There are just two possible paths to get to the same result, i.e. a road, and the developer is entitled at law to come to you and ask you to use this one. And as Mr. O'Connor has said, this has happened before.
Well, I'll ask the question rather bluntly then. Is there an advantage to the developer in having it dedicated rather than vested?
My answer to that is that's not a relevant question for you.
Depending other people's legal rights. It registered in 2003.
Okay, so the question's been asked and answered. Are there any further questions? Okay. Vicky, yes.
Different issue. The developer's lawyer explained to us at the last meeting, and I just want to check whether this is your understanding as well, in terms of the parties to this, that I think he said, going from memory, so I may have it wrong, I think he said 7 in favour of, had signed something in favour.
Well, perhaps I can clarify that, because there has been some further communications about that question, and then I have undertaken a cross-check. There are 13 titles, land titles, which hold the covenants, which own, if you like, the covenants that are registered on this piece of road, this piece of land to become road. Of those 13, Infinity hold, I'll use the word discharge, it's not actually, that's not what the document's called, but they hold documents where those 7 of the title owners have agreed to withdraw the covenants.
Doesn't mean they support it.
There are 2 who Infinity, and I've seen the document, have non-opposition agreements. So while they haven't said here's our discharge, they won't oppose the discharge, and there are 4 opposed.
Thank you.
Thank you. Dion.
I just wanted to ask a question whether the mortgagees of the particular landowners have been notified.
I do not know the answer to that question.
Because in order for us to make a decision, as far as I know, just reading some of the legal understanding of this, they need to be notified as well.
That again is not a question for you. It's a question.
Yeah, but we can't make a decision under the Public Works Act 1981 under Section 18 unless the mortgagees have been informed.
Sorry, you're not making the council's decision is under a section of the Local Government Act 1974. You're not making a decision under the Public Works Act.
So if you were to phrase the question a different way, can we make the decision we've been asked today in the absence of that information?
Yes.
The answer is yes. Thank you. Okay, so we've exhausted all questions. Great. So Yanni would like to move. Well, there are 2. There's a staff recommendation and there's a community board recommendation. Yanni is moving the community board recommendation and Jimmy is seconding that.
Yes, I'll foreshadow the staff recommendations, or however you want to do it.
So Vicky, you're foreshadowing that in the event that what has been moved by Yanni and seconded by Jimmy fails, you will then move the staff recommendation. And would there be a seconder for that at that point? Yes, there would. Okay, great. So that's the context in which we're working in. Now, we have therefore got the community board recommendation moved and seconded. Is there any debate on that? Yanni.
Thank you. This has been a long-standing issue in this local community. It's been in front of council and the board a number of times. A number of us as councillors have said that we support the community boards being, local decision makers, and I think, in fairness to the complexity of this case and the work that the community board has done on it, that we should respect the resolutions that have come from the local community board. It's not an easy issue to deal with, I understand that. It is very complicated, but actually, I think for me, the issue should be resolved through the private parties, not through council making the dedication as we've been asked to do. And I am particularly concerned around the issue of a suitable guarantor. And given the history of this development, I would find that an incredibly risky proposition for us to make. So I won't be supporting the staff recommendation. I'll support the local community board, and that's why I've moved the board recommendation. I would say that I do also struggle to understand why the stormwater is not related to the roading. It seems to me very hard to design a stormwater system without knowing what your roading system is, and surely they should be done at the same time. So I personally can't see how this can be resolved until it's resolved between the two parties, and I don't believe we should be making one decision today that could possibly prejudice the outcome of other things outstanding.
Jimmy. Jimmy.
Thank you, Chair. Yeah. During the community board meeting, I supported the majority community board members' decision go to the option 2. But today in council table, in my view, decision no any change. Because as a councillor for more than 6.5 years, I never seen a issue like this one. It's so complicated. And regarding to the Resource Consent Act, and also the contentious for extension for more than 6 years. Other one is we gathered lots of information from the staff information, from the legal advice, and also from the developers the deputation, as well as landowners deputation. All those information give to me, if council will go to the option 1, to dedicate the road rather than the option the 2, to kind of there's through the court case, the situation, probably more or less is a risk for council overriding this Resource Consent Act, and also this subdivision, the consent one. But if we review the staff information, particular, open to us, if we compare two options, it looks like still the option 2 much better than the option 1. Because why, if you review here, particular staff show us the perception by the landowners who have interest in the land. Then the council is using an unusual step to dedicate the road in favor of the developer only and ignore the other landowners' right and interest. That's the staff the information, and also in here particular written. The council not being involved in removing the covenant under the Property Law Act. Therefore, there are no other disadvantage in option 2. So the developer still proceeds with the variation and relating the safety the improvement. If that's true, why we are not go to the option 2 rather than the option 1? And also the reason we as a council, we receive the information. Some of information, even right now, I still know any confirmation, the answer. One is from the David Barker one. He particular give the remind us the authority under the Section 17 Public Works Act 1981. Has been taken completely out of context and should not be used the subdivision plan. But regarding the staff answer, still the difference. So, but for us, in the short time period, how do we to identify, which one is correct? And also, we receive the information from the lawyer, the coverage lawyer, to the developer, original developer, Noble, and some other landowners. The particular emphasis in here, you will be aware the access sought is a temporary measure only, because once the new intersection opens, Lot 22 must wait as a legal rule, as per the covenant recorded on your client's title and resource consent still obtained by the developer. So this quite clearly, give us a signal. This should be go to the court, through the developer, to remove those covenants, rather than council, to kind of the, to kind of to do the way. So based on this, the information, that's why I still prefer the option 2 rather than option 1. Otherwise, I'm still concerned more or less a bigger risk for council overriding this resource consent subdivision issue. Thank you.
Dave.
Thank you. I find myself in a rather invidious position here where legally we are told that we have little option but to go with this resolution, but my reasoning and logic in me raises alarm bells that something's not quite right in this whole process. It's been going on for a long time. I wasn't at all happy with the explanation between dedication and vesting. There have been a number of questionable processes in this whole dealing, and I really feel that it should not be this council that is making a decision like this at this time. There are so many things that are unresolved between property owners and the developer here, and with some regret I'm not going to support the staff resolution. I am going to go with the Community Board resolution for a number of reasons which have been adequately explained by Councillor Chen and others. Thank you.
Vicky.
You'll be surprised to know that in the Community Board resolution, which wasn't unanimous, that the council, item 2 of that, the council agrees to meet with the adjoining property owners to discuss options on a way forward. So you're actually suggesting that the council become the mediator in this dispute. I am not at all in favour of that. This has been going on for a very, very long period of time, and it is a dispute between private property owners. I am not keen that the council puts itself middle and centre of that dispute and takes a huge amount of, well, I don't know who's meeting with them, whether it's councillors or staff or who thinks that they're going to resolve this issue, which is currently at arbitration. I think that's a very dangerous precedent for the council to set. When we were at the Community Board, the legal advice could not have been clearer. It's seldom you get such clear legal advice on the implications of the resolution. That was incredibly clear at the Community Board. It was incredibly clear to us last time. The issue for the council is a range of issues. As we heard just before, as I understand, there are 13 titles, of which 7 have agreed to the conditions.
If I can ask people in the public gallery please to remain quiet. Thank you.
And 2 have signed a non-opposition. That leaves 4 in opposition out of 13, as I understand it. And that's the information that I've been given. I just think that in this issue, there were other issues raised at the last council meeting where one of the speakers talked about the safety of Yaldhurst Road, and that strikes me as really, really important in this issue. We have traffic lights that have been unusable for a very long period of time, and consequent risks to users of Yaldhurst Road. Whatever happens in this case, it will end up, no doubt, as a dispute between private property owners. That's fine. I am not keen that the council becomes centre of that dispute, and I am not keen that we put ourselves at risk from what we do. So, because we've had that very clear advice, I want to go with the staff recommendation as I supported at the community board as well.
So, like Jim, Aaron.
Yeah, I do share some of Councillor Buck's concerns, and because of that, and to maybe help get the result that some of us want to see here, I'd ask that you put 1 and 2 separately.
I'm happy to do that.
Because I would agree with Vicky on the second one, that I don't really want the council involved in that, but the first one, I have reasons for voting the way I will, and I'll vote in favour of supporting the community board. It wasn't unanimous, but that's democracy. But democracy is that community board. Jimmy's also the councillor for that area, and where the traffic lights are, I'm on the other side of the road, so we're neighbours there, so we share the concerns. I just want to touch on a couple of things, because everything else has been covered. With the 13 titles, 7 withdrew their opposition. They didn't support. I think that's a considerable difference in the wording. They withdrew their opposition. They didn't say, yeah, hey, we're really keen to be reamed. I think they just said, look, I think some of them have given up. 2 went for a non-opposed, and 4 will probably die in the ditch over this one. They will fight this to the end of the world, and they have a right to do so, because they stand to lose a lot. They stand to lose a lot because there's been some dubious practices involved in the subdivision. We are not voting on that today or have anything to do with that today, and that does not even play into our decision making. But the thing I will highlight is that there is a court case where the developers are being taken to court for constructive fraud, and that does concern me, because we will be dedicating, or potentially dedicating, a road which is part of that case into our name. And for me, there's alarm bells there, and I just think if you're a cautious sort of councillor, then you would go for the community board option, which is to just steer clear of this. And it already says it's going to go through the courts and let it be sorted there. Why would we play lawyer, judge and jury and come up with a decision and dedicate this road? I don't think we should, and so I'll support the local councillor and the community board in what seems to be the better of a bad situation.
Sarah.
As a cautious councillor, I'm actually going to be following the legal advice. They're really clear. I'm really uncomfortable with the history of this, but the history of it has become a civil matter and not one that we should be stepping into. And so I completely agree with Councillor Buck there. And
if I can ask people in the public gallery, please to remain quiet. Thank you.
We've been presented with a report which details, something that we have, that the applicant is legally able to ask us to do, and I'll be following the advice there and going with the foreshadowed motion and against this one here.
Like Jimmy, I've never seen an issue like this, and I hope I never see an issue like this again, as I'm sure other people in the room would agree. This is complicated, it's long-standing, it's contentious, and there are a number of aspects of this that are really an ongoing and protracted private property dispute. And as I said at the last meeting, there's little that we've seen that suggests that protracted private property dispute is likely to be resolved anytime soon. Separating out what's relevant to the question that we've been asked today and what's not relevant to the question that's been asked today has also been quite complicated, and there was a lot of time spent on that at the last meeting as well. My natural instinct would be to go with the local view, to go with the community board, to go with the local councillor. And again, we've taken advice around the 2 options that are in front of us today, the 2 approaches that are in front of us today, and what we've heard is that this quite rightfully has been put to us as a valid process by the developer. We maybe haven't seen this happen too many times in the past, but it is a valid process, and it's one that has happened in other territorial areas, and that we've heard this afternoon has happened in our area in the past as well, albeit maybe on a small number of occasions. But more than anything, I've heard the legal advice, some of which has been provided to us in public excluded, and I've heard that loud and clear. And in terms of balancing the various aspects of the decision that we've been asked to make, there are a number of things that we've had to take into account, and that balancing act is one that we're all very, very used to. But the balance for me is one where I'm going to totally rely on that legal advice, and therefore will be voting against the motion that's in front of us at the moment, and supporting the foreshadowed motion that's on the table. So Dion.
Can I speak as well?
You hadn't indicated you wanted to, but yes, you can.
All right, no, I just wanted to quickly say that I'm actually going to support the community and the people in this who have come to us as well. And I just wanted to sort of liken it to an email I got a few weeks ago saying leadership is about doing what you feel is right. And sometimes laws aren't right, and sometimes doing legal process isn't the right thing to do. And indicated by what is on the board up there, that they're going to go through a legal process. Let the legal process work out what's right for these people. So I'm going to do what I feel is right, and I'm going to show some leadership to our citizens of Christchurch and vote for them to take this private matter and work it out that way. Thank you.
Okay, so so the motion in front of us is the Community Board recommendation. So if you're in favour of the Community Board recommendation, you will vote yes. And if you're not in favour of the Community Board recommendation, which is the text in blue in front of us, you will vote no. So all of those in favour? Oh, and I'm going to put it in two parts. Yes, I am, and thank you for reminding me of that. So I'll put paragraph 1 first. So all those in favour? Aye. Against? No. Can we have a division on that, please?
That's in random order. So Councillor Johansson?
Yes.
Councillor Sweets?
Yes.
Councillor Templeton?
No.
Councillor Manji?
No.
Councillor Kieran?
Yes.
Councillor Galloway?
No.
Councillor Chen?
Yes.
Councillor Davidson?
No.
Councillor Cotter?
No.
Councillor Turner?
No.
Councillor Goff?
No.
Councillor Buck? No. Councillor Livingston?
No.
Councillor East?
Yes.
So that's lost 9-5.
Okay, so then we'll put paragraph 2. All those in favour?
Mr Chair, can I just one point of clarification, which I should have updated you.
No, I can't do it.
In relation to the resolution,
I'll take the further advice, and if I could once again caution those in the public gallery to remain quiet. Thank you.
at the last meeting, we asked the councillors to add in lot 600 into the resolution. I've been advised that the council does not need to make a resolution in respect of lot 600, so I'm not sure whether the resolution, because I can't see it, whether the proposed resolution includes lot 600.
No, it doesn't.
So this is advice on the staff recommendation.
Yes, advice on the staff recommendation.
Okay, so when we get to considering the staff recommendation, so when we come to the staff recommendation, what we're hearing is that that does not need to include any specific reference to lot 600.
Yes.
Thank you. All right, so let's finish. I mean, there's a question really as to whether 2 stands on its own anyway, but we'll put it in as much as it's been moved and seconded. So part A, option 2, all those in favour?
Yes. No.
Against? No. So that's lost. Okay, so now we come to, Vicky, your foreshadowed motion, which now becomes the motion that we have on the table, which is the staff recommendation. Do we have a seconder for the staff recommendation? Anne Galloway, thank you. Is there any further debate on this? Okay, so I will put that motion. All those in favour? Aye. Against? And if we could please have a division on that as well.
So, Councillor Hewitt.
Is it me?
Yes.
Yeah, I'll go no.
Councillor Gallagher. Councillor Chan.
No.
Councillor Davidson.
Yes.
Councillor Cotter.
Yes.
Councillor Turner.
Yes.
Councillor Goff.
Yes.
Councillor Buck.
Yes.
Councillor Livingston.
Yes.
Councillor East.
No.
Councillor Johansson.
No.
Councillor Sweets. Councillor Templeton. Councillor Mangy. So that's carried 9-5.
So we'll declare that carried. Thank you.